Hi, everyone, and welcome to today's webinar. My name is Anna, and I'm with the New Mexico Small Business Development Center. Today, we have Larry Donahue joining us, who is a seasoned high-tech business executive and 30-year attorney. Larry will be presenting Keeping Your Trade Secrets Yours. We will be using the Q&A function to take questions and welcome attendee participation, so don't hesitate to ask us any questions you may have. We'll answer those questions during and at the end of the webinar. Thanks so much for joining us. And without further ado, I'll hand it over to you, Larry.
Thank you. I appreciate it. And hi, everyone. Thank you for joining us. Before I jump into my presentation, I just want to throw out a few administrative issues really quick. And the first one is COVID resources. I know we are tired of COVID and the pandemic, but as business owners and leaders, you need to care about it a lot. So you need to make sure that you're abiding by all the rules and requirements with your local and state officials, number one, whether you agree with them or not. And two, you really need to follow the CDC guidance. And is there a legal requirement to follow the CDC guidance? Maybe not if the governor or your local regulations haven't dictated that you do, but you really want to, because if somebody gets sick on your watch and you're not following the CDC guidance and suggestions, guess what? You got a potential negligence claim you may have to defend against. So I'd like you not to be involved in a lawsuit. And I promise you there's a lot of attorneys out there in my profession that are just gearing up for all kinds of lawsuits against businesses who weren't following CDC guidelines or otherwise not following legal requirements. And I don't want that to be you. So here's these resources. You should really be aware of what your requirements are. And also different businesses have different types of requirements, as you might imagine. So it's important for you to understand what are the specific, either requirements or recommendations for your industry, and you need to be following those. My name is Larry Donahue, and I'm a lawyer. I've been a lawyer for approximately 30 years. Before I begin, just what we say here, mute your audio if you can. If you set your Zoom ratio to fit window, that'll help you see the text clearly. And then there is a Q&A function with Zoom, and I encourage you to type in questions. The more questions, the better. It lets me know that you're paying attention, number one, and actually finding this stuff useful. So what are we going to talk about today? We're going to talk about trade secret information, and in order to do that, you need to know what it is. You need to know how you can protect trade secrets, and then how contracts fit in with all of that. So we're going to spend a lot of time talking about those two topics. And my hope is at the end of this presentation, you're going to know what trade secrets are and how to use them. You're going to know how to use contracts in the right way for confidentiality and trade secret information. And then you're going to know a little bit more about non-compete, non-disclosure, and non-solicitation. Those are actually really important concepts. And it turns out when I talk to business leaders about those things, everybody likes to skip over the legal jargon and just read the headers in a contract. Well, newsflash, headers don't matter. It doesn't matter what the heck the header says. If the legal language below the header does the exact opposite of what's in the header, it's the legal language that matters, not the header. So we're going to talk a little bit about what to look for when you're thinking about contracts or somebody stuffing or shoving a contract in front of you, what you need to look for. Now, finally, before I begin, I do have to have my disclaimer. While I am a lawyer, I'm not your lawyer. I can give legal advice, but the New Mexico SBDC is not a law firm and cannot give legal advice itself or themselves. And so therefore, all the material here you should sort of view as general advice and not legal advice. And it's not going to come as a shock to you, but it took me 3 years to study law in law school 30 years ago. And I had to read probably a whole set of encyclopedia worth of information to graduate. And the point I'm trying to make is even though I can tell you very specific things about the law, there's a million exceptions. And what I might be saying could actually be the total opposite for you if you have a different set of circumstances. So I try to talk about what the common rule is or what the general approach is, but it could be very different for your specific circumstances. So don't take what I tell you as the rule of law, but just general guiding points. So let's begin. And before I dive into trade secrets, I kind of want to give you an overview a little bit about what can be protected from a business perspective when we're talking about intangible type stuff. You know, intellectual property is what it's called. Stuff that doesn't necessarily have a title or an asset that you can pick up and hand to somebody. So I group protection of intellectual property into two general buckets. The first one is you versus the world, meaning can you protect your intellectual property against everybody else in the world, whether you know who they are or not, whether you have a pre-existing relationship or not. One of the areas of intellectual property is trademarks. Trademarks, if you think of like FedEx, Apple, you know, Corning, Amazon, what do these names instill? McDonald's, what do you think of when you hear these names? What you should think of is the product or service that those names are associated with. Chanel, you know, these names, Gucci, they're gonna instill a picture in your mind, a feeling, a type of brand, high-end, low-end, Chevy, Cadillac, right? Jaguar, Mercedes, Volkswagen. How do these brands, these names instill an emotion? That is what a trademark protects. A copyright is very interesting, and it's different because a lot of people get these two things confused, trademarks versus copyrights. Copyrights protect expressions, works of art, unique work product. For example, photos, pictures, drawings, poems, books, articles. Those are subject to copyright. The Mickey Mouse character, copyrightable, and it protects the expression of an author. So somebody who, Michelangelo, if he was alive today and did the statue of David, he would own the copyright in that. And it protects the statue itself. It doesn't relate to branding or naming. It relates to the actual thing that was constructed, a piece of software. And copyrights are very valuable because it prevents, or let me rephrase this, it gives the copyright holder the right to control how that thing, that work product is utilized. You know, can you sell it to somebody else, transfer it, lease it, show it publicly? Can you create derivative works? So if I'm Michelangelo and I create a statue, can somebody take a photo of it or a video of it or come up with another statue that's a little different for some reason? The answer is no, unless I give them permission, because I own the copyrights and therefore control what people could do with the object of the copyright. It's a very different thing from a trademark. Another source of protection are patents, and most people know what this is. They're ideas. But they aren't just ideas. They're ideas that are actually something that work. So it's an invention. You know, I always say, you know, ideas are like elbows. Everybody has one, but most people don't have the ability to take that idea and make it into an actual working prototype, for example. That's the invention. So an invention is better, stronger than an idea. An invention is an idea realized. But not only does it have to be an idea realized, it also has to be unique, non-obvious, and novel from the prior art. Meaning you can't just say, oh, I've decided pink umbrellas. I'm going to patent that. Well, no, you can't, because that's not really non-obvious from the prior art being umbrellas. You know, you can't also say, oh, teleportation, that's my idea, I'm going to patent that, because you haven't created a working prototype unless you have, then by all means. So those are the biggies, but there's one more, and that's trade secrets. And that's what we're going to talk more about today. Now, there's one big difference between trade secrets and the other three that I just talked about. The other three, trademark, copyrights, patents, I have to actually submit an application somewhere. I have to pay the fee somewhere, and I have to meet all the requirements. So for instance, patents, I talked about unique, non-obvious, and novel. So I have to meet certain standards, and I got to go through a lot of work and pay some money to do that. Trade secrets are the opposite of that. Trade secrets, I do not have to notify anybody. It is a private thing with our companies, and there's no registration, there's no money to pay, but yet I can enforce it against the rest of the world. And so that's a really powerful concept, and that we'll dive into, deeper on what is a trade secret, how do you define it, and how do you protect it, but and enforce it. So it's going to be important to know that, but there's no registration requirements, so no costs. So it's a really effective way of creating some value for your company if you do it correctly. So there's one more piece of protection, and it's narrower, meaning we can't use it against the rest of the world. We can only use it against a specific third party. It's a contract. So the contract has parties. That's called privity of contract. So the privity of contract exists between the signers of the contract, and that is who can be held to account in the contract, the terms and conditions in the contract. So while a contract is less interesting and helpful than the other four I mentioned, because it is doesn't apply to the whole world. It only applies to the individual that has signed it. But on the flip side, I can enforce a lot of things with that other party that I probably couldn't do otherwise. So contracts provide a really important component to protecting your intellectual property. And we're going to dive much more into that in a moment. So now I've given you a high level of the general concepts of protection, but let's focus in on the trade secrets. And the first question you have to ask yourself is, what do you want to protect? And the better question is, what is valuable to your business? And are there secrets that you care about that you need to protect against? Or more, another way of asking this is, if you had some information in the hands of a competitor, would that be a problem for you or not, right? And if you're going to say yes to that, then you need to think about how to protect that. So aside from secrets, what else could we have? We could have customers and clients, right? Client lists, information, employees, possibly, and employee information, key contractors, vendors, partnerships. Those are things that could be valuable to your business. So how does that relate to trade secrets? Well, let's dive in a little deeper. What would be examples of secrets that the business might want to keep confidential? Recipes and formulas are the biggie. So we have a lot of, especially in New Mexico, a lot of salsa manufacturers. We have a lot of restaurants with unique foods and tastes. Just because restaurant A is creating delicious green chili enchiladas doesn't mean there's a recipe there to protect. Even though a lot of restaurants have green chili enchiladas, if you have a unique set of ingredients and a recipe that you use that you believe makes your restaurant better than the rest, yes, you have something you need to protect. That is something you should be considering a trade secret. What else? Critical processes, workflows, know-how, things that aren't generally available. And by the way, we did have a question here. Let me read it. Jeff asks, I'm forming an LLC now with a killer idea. I wrote out the idea in depth and mailed it back to myself and have it unopened. At least I have a postmark date. How legit is that? That's a great question, Jeff. And the answer is, not very. At the end of the day, it could serve as proof about your idea in that certain date. You had that idea at a certain date. The bigger question is, when is that relevant? Are you going to come, somebody's going to use your idea and then you're going to say, hey, I had that idea before you? Maybe, but the idea needs to be protectable. Otherwise, people are allowed to have similar or same ideas all on their own. So just because you have a cool idea doesn't mean somebody else doesn't have a cool idea. And just because you mailed that to yourself doesn't give you rights necessarily against other people. You have to do more with the idea. You have to express it tangibly if you intend to use it long term. And mailing it to yourself can certainly give you a date as it relates to when you had the idea, but you have to ask yourself, when is that going to be relevant in terms of protection? So you need to take it to the next step. Is that idea something that is patentable or not? If it is, the better date is what's called a provisional patent. A provisional patent provides a filing date that is really important and very helpful. A provisional patent gives you a year to perfect it and get what's called a utility patent or method or pattern patent, which is a perfected patent for what your idea is. You have a year to do that. So the provisional patent buys you some time, and you get to use the filing date of the provisional patent for when your idea is considered patentable against others. So if you have a cool idea, I would encourage you to get the provisional patent right away. They're not that expensive. It's a little expensive, but you don't have to define all your claims and go into a lot of specificity. You do that with a utility patent later down the road. I hope that answers your question. And if not, please send in some more questions. What else? We care about vendor and partner lists, for example, or you should, I would assume, mailing lists, customer lists. And then what about strategic planning, acquisitions? Are you talking with partnership opportunities for your business, merging? Those could all be trade secret information, competitive information that you want to keep out of the hands of others. And so the question is, well, how do you do that? So the answer comes into the legal definition of a trade secret. And this is what it is. First, it is information such as formula, pattern, compilation, program, device, method, technique, process, something that is documented, it's available, provable what it is. But it's not just information. It's also valuable information, something that is economically valuable, that is not generally known in the public, and it cannot be readily ascertainable by proper means. And what do we mean by proper means? Well, maybe we can ascertain your recipe by, stealing your recipe book. Well, that's not proper means. So that wouldn't qualify. But if you had, I don't know, sugar water, and it's easy to ascertain the ingredients from that by proper means, simply by tasting it or something like that, then that probably wouldn't be a trade secret. Finally, you have conducted some level of reasonable efforts to maintain the secrecy. So you don't get to just define a trade secret and then announce it to the world. That won't work. Also, if you're kind of negligent about it, that won't work either. So I'm going to summarize this for you in the following way. It's information that's valuable, not generally known, not ascertainable by proper means, and you've been working to keep it a secret. If you have that, you have a trade secret. And that is what we are after. So how do you obtain a trade secret? There's, like I had mentioned earlier, there's no registrations required. You need to just simply start treating your secret information as an actual secret. You know, what does that mean, right? How would you start treating stuff as a secret? Well, you should label it at the very least, right? Label it secret and confidential, or, you know, confidential and do not distribute. If you have documents, you should probably put that on the footer or the header somewhere. If you have like a recipe list or a formulas, you should probably keep that in a specific location. You should probably lock it up at night or when not in use, and you should only allow those who have a need to know it, right? I think that would be reasonable means and efforts to hold things confidential. If you have recipes and you got them strewn about on your countertop that customers can see or any employee can see, well, it doesn't seem like you're really trying to keep it very secret, and you're probably going to lose it. So treat it like a secret. One example I like to use is the Coca-Cola formula. When I use it, I found not everybody thinks of it the way I do, but I imagine the Coca-Cola company has like this vault in the basement, was surrounded by guards and guard dogs and barbed wire, with the magic formula on a pedestal in the middle of this walk-in, you know, vault. That would be reasonable means, you know, or that would be their attempt to keep it secret. I'm sure they don't have it like that, but you know, the point is that you want to keep it sacrosanct in your, you know, business, and only those that you trust and have signed an agreement to keep it confidential and not disclose. We're going to talk about that some more in a minute. Those are the folks that you should be allowing access to the secret stuff, the secret sauce. And I got to tell you, if I had a nickel for every business owner that calls me saying, hey, I want to go after my former GM or former employee, they went and stole my customer list, called up all my customers, and this is not an exaggeration. We've had instances of former employees not just simply calling up the customers. We had an instance, this is down in Las Cruces a couple of years ago, where the employee used the customer list to tell all the customers that the company has moved. So yeah, think about that for a minute. They literally used the same name as their employer, opened up a new store down the street, and told all the customers they've moved, now come here. I mean, there's a million things wrong with that, of course, but by them being able to have access to the customer list made it a lot easier for them to try and pull off that kind of ridiculous theft. But we've had a lot of others too, much more, you know, surreptitious, like reaching out to customers with, you know, just announcing I'm no longer with my employer. I have my own business over here. You know, it's kind of like an innocent, I'm just letting everybody know that I've moved on. It's like, well, that's not your right to do. Those aren't your customers. Those are our customers that as an employee, you were servicing. You're not entitled to tell them you've moved on, but you can certainly do advertisements. You know, you know, we can't control, you know, general public announcements, but we can certainly control if you're going to reach out to people specifically and individually. So customer list is a really big thing that nobody should overlook. So what is really cool about trade secrets is this last bullet here. It's not a mechanism just to go after the thief who took the information. The law allows you to go after who uses the information. And that's what's really key here. Think about that for a moment. If you have an employee who steals some trade secret information of your business and takes it to your competitor, you can use trade secret law to sue the competitor as well as the employee. You can prevent the competitor from using that information. You can sue for damages. You can do a lot of work against a competitor who uses trade secret information. Now, if you're smart in thinking about that, that also means you should not use trade secret information yourself, because you might have a lawyer like me or somebody else dragging your butt to court, and that can get extremely expensive very fast. So if you have an employee or recruit that says, oh yeah, I can bring all my customers over, not so fast. You know, one, is it, excuse me, trade secret information and going to get you into trouble? Or two, do they have some sort of contract in place that prohibits them from doing that? A non-solicitation or non-compete. We're going to talk more about those in a minute. But if they have those, you may also be in trouble for tortious interference of contractual relations. So beware of any employee saying, oh yeah, I'm going to bring the keys to the kingdom of my former employer. Aside from the fact that there could be a lot of legal ramifications for you, ask yourself, what kind of person is that? And will they do the same darn thing to you in a few years when they eventually get tired of you or feel like you're not paying them enough or something? So you really need to avoid that. And I hope you're listening to me. And the reason I say that is I make a lot of money with businesses who are getting in trouble hiring the wrong type of employee. So don't let that be you. So as I mentioned, and I hope it's sunk in, is you need to maintain the secrecy of that information. So you don't want to make it publicly available. You want to use reasonable efforts to maintain the secrecy. I mentioned, you know, locking it up and on a need-to-know basis. And you need to put this, you need to label your folders, you need to label your documents as confidential and trade secret, do not distribute. Now that is not the actual legal language defined in the statute. That it is just my recommendation. So you can feel free to rephrase that or tweak the language to meet your branding or specific communication style with your business. But when you label stuff very clearly and conspicuously, then that is a great way to show, you know, we are trying to treat this stuff confidentially. Now, the other thing you need to think about is training your people as well. You know, they need to understand, you know, what is a trade secret, number one. They need to understand, you know, how to maintain the secret, and they need to know the ramifications if they release that kind of information. So don't forget about training people. And then finally, there's a contract component to this. You do not have to have a contract to maintain a trade secret, but it helps. And I got to tell you, you know, as I said, I've been a lawyer for 30 years. I've been dealing with trade secret stuff the whole time. And what I really love, you know, it's just a beautiful icing on a cake, is when the other side hires an attorney that doesn't know anything about trade secret law. Maybe it's their father who's a criminal lawyer, or a friend, or who knows what. And sure enough, that lawyer calls me up, reads me the riot act. How dare I threaten their client on trade secrets, because don't I know that there's no contract that says that? And, you know, it's just, you know, there's a heavy sigh when I'm talking to that lawyer, and it's like, you know, all they're doing is generating conflict. And don't get me wrong, I love conflict as a lawyer, but it costs money. It costs my client money, it costs their client money. So they're just being stupid for no reason whatsoever. So, you know, then it's my turn to explain, well, you obviously don't know anything about trade secret law, and unless you want your client in court trying to explain all of this, you need to change your act really quick. And, you know, it's just annoying. But if you have a contract, remember it's not required, but if you do, there is specific language you want in there, and that gives you a federal option. Otherwise, typically, trade secrets are tied at the state level. And so you need to be a little careful too, right? Because if you have a customer in Arizona and they go and release your trade secret information somehow, maybe you inadvertently emailed them or something. Well, which law do you apply? New Mexico or Arizona? Where do you sue? New Mexico or Arizona? And the answer to those questions could mean a much less expensive fight or a much more expensive fight. So having a contract helps you lay that groundwork, number one, and then two, gives you the federal option, which has a number of interesting benefits. So finally, I want you to think strategically. You know, if there was a theft of trade secret information, how would we prove it? How would we prove your employee stole the customer list? How would we prove that a customer who you shared the recipe with ended up taking that recipe and starting their own business, and in fact, it's the same recipe? How do you prove that kind of stuff? I'll give you one example. If you have your customer list populated with some decoys, some honeypots, and what I mean by that is, let's say you are a spa or salon, and your customer list isn't huge, but put one or two different fake names in there with a PO box or mailing address that isn't generally known by your employees. And so if an employee leaves and steals the customer list and they send something to everybody in the list, they're going to send it to the honeypots. That's great evidence, right? Because that doesn't exist. There's no such person as Jane Doe at 123 Main Street, but that happens to be an address I control. And look at this. This is your flyer, isn't it? So how did you get this address unless you stole it from me? So that's a great way to do it. Recipes, things of that nature are harder, unfortunately. So you could put in odd ingredients that don't otherwise go in there, or dye it a certain color that isn't standard. And you could potentially use those as examples. But there's also then they had the means, right? So they had access to the recipes or the formulas or whatever. And now it looks a lot like yours. But think through how you can create some sort of mechanism to prove that they actually stole the recipe or trade secret. Then that makes my job as a lawyer a lot easier. And when you hear a lawyer say easier, think less expensive. So the other thing is you need to be aware of is the flip side of this coin. Just because they're doing something similar doesn't mean it's a theft of your trade secret. So it really helps to understand or have some sort of mechanism to be able to prove the theft so that at least it weighs in your mind that it wasn't an actual theft. They just, they liked the way things worked with what you're doing. And so now they're trying to replicate that. And there's really not a lot you can do unless they have violated some sort of right or a contract. And we're going to talk about that in a minute. So let's dive into contracts now. So contracts are a bargain for exchange of value between two or more parties. So between you as a company and your employees, for instance, but it needs to have some value exchanged. And in New Mexico, keeping your job is not considered value, not considered consideration. It needs to be something more than that. So if I wanted to force existing employees to sign a contract, I can't just say, well, to keep your job, you got to sign this contract. I'm not going to be able to enforce the contract. I need to say, give them a bonus, even like $100 or $10. If they're willing to sign a contract for $10, that would be consideration, and that then would be enforceable. But with contracts, we can protect anything, ideas, concepts, anything that the other party's willing to sign within reason, right? We can't force people into slavery and bondage and things like that with a contract, but we can certainly get them to acknowledge certain rights of your own or your business relating to intellectual property, ideas, concepts, and so on. So the contract can give you potentially a lot of power with whomever is the other side signing it. So for example, if you have a great idea and you don't want them to take that idea, you can certainly have, like It's not just an NDA though. It needs to be more than that. They're not going to use that information on top of it. So they are very flexible and can be utilized in a lot of different ways. Normally what you'd think of with employees, contractors, partners, vendors, people that are walking in to your premises with a wet signature. But you could do things like website visitors and website users, customers, people that log in. You can do what's called a click wrap, or even just an online terms of service and say, our services are subject to the terms of service that is available on our footer. And that will work in most instances. And then finally, you can wrap them around a product. And you see this, used to see this a lot when you get a piece of software from Microsoft, for instance. It was considered a shrink wrap or an insert or enclosure with your particular product. And that will work in most instances as well. Contracts can maintain accountability and establish duties and obligations of the parties. It can ensure payment and or penalties for non-compliance or breach or failure to do something. It can permit termination when needed and how you might terminate. It can establish or limit warranties, indemnities, and liabilities. Now, why might we want to limit warranties? Well, depending on the kind of business you are, there are things called implied warranties. If you sell products, there's an implied warranty of merchantability. There are possibly implied warranties of non-infringement, of fitness for a particular use, and you may need to limit those, and there's very specific ways you do that in your contract if in fact these you don't know what these implied warranties are, or they are against what you're trying to do. For instance, if you're selling a refurbished or as-is kind of product, you're still going to have the implied warranties on that. So you may need to disclaim those. And likewise, if somebody's going to go and use your product or service in a crazy way that hurts somebody, you don't want to be liable for that kind of thing. So you need to make sure that they indemnify you and hold you harmless if they do something stupid with your product or service. It can control how disputes are resolved. You can do forced arbitration. You can force them into mediation. You can control or reduce expensive lawsuits with how the contract is written. And one big way is attorney's fees. And the reason I say that is if somebody is not acting in good faith, they think maybe they have more money than you, or they think that they can out-sue you, or something like that. Well, if you have an attorney's fees clause in there, then that really escalates the risk on the party of somebody not acting in good faith, because they may have to pay your lawyer's fees. So they're probably going to be more interested in negotiating with you and settling with you than, trying to cause you to spend a lot of money in attorney's fees if they will end up having to reimburse you for that. The issue here, though, that's also really important and is more subject to this seminar is establishing confidentiality, non-competition, non-solicitation, and trade secrets. And so we'll go into more detail on that in a minute. Some things you need to know about what contracts cannot do. They cannot be enforced against third parties that aren't a party to the contract. So there's one minor exception, by the way, that seems to be coming up a lot lately for me. And that is what's called tortious interference in contractual relations. So if you are an employer and you want to hire somebody away from your competitor, you can do that. There's no problem with that. But if you know there's a contract in place between that employee and that employer, and you would cause the employee to breach or improperly terminate the contract, that employer then could have a potential cause of action against you. So in this particular case, it's almost like, the more wisdom and information you have, the more it can bite you in the butt. So if you hire somebody or you do something not knowing there's a contract in place, excuse me, that can actually help you. But you can't be, force yourself to be ignorant either. There's a reasonable person standard that would apply to this. Contracts cannot override, excuse me, they cannot be overridden by verbal promises. And I want you to really hear me with this. If somebody puts a contract in front of you and then they start blathering on about what's in the contract, you need to tell them, please shut the hell up. I need to read this. And the reason being is it doesn't matter what comes out of their mouth. I dealt with cases like this where they actually say the opposite of what's in the contract. And guess what? It's what's in the contract that matters. It doesn't matter what the hell came out of the words that came out of their mouth. So don't listen to people and politely get mad at them and say, listen, look, I'm sorry, no offense, but it doesn't matter what you say. I have to read this contract because that's what matters. So let me read it myself, and then I will sign it if I feel like I want to sign it. Finally, contracts cannot be perpetual. They have to have a very specific duration. Some contracts can be really long, like a 99-year land lease. Those are probably the longest I've heard. Can't really be a lot longer than that. But in general, you need to have a specific term. So if we're talking about vendors, partners, contractors, employees, 1 year automatic renewal without notice is fine. I've seen 3-5 year type contracts, little rarer to be on the 5 year, but I've seen them. I've seen a lot of business leases that might go 1, 3, 5, 7, 10. The 7 and 10 is kind of on the long side. And I would definitely encourage people not to sign leases that are even 3 or 5 years if you haven't done the business before. Leases are going to generally be your number 1 or 2 expense. And if you haven't done the business before, remember that there's an 80% or greater failure rate for most businesses within the first 3 years. So lease is going to force you to sign a personal guarantee. You could be saddled with that burden if your business doesn't succeed. So a lower term lease is always going to be beneficial, even if it's a little bit more money, until you know your business model works, you're going to be cash flow positive, and things are going to be okay. So let's talk about non-competition versus non-solicitation, your standard non-compete clause. I can't tell you how many times people tell me, oh, non-competes are unenforceable. And the answer is no, that's not true at all. It depends on the context, in the circumstances, in the parties. So for instance, if you're a medical professional like a doctor or dentist, yes, non-competes are not enforceable. But remember, we're not looking at headers. We're looking at the actual legal language. And people can get confused between non-compete and non-solicitation. So it's perfectly legitimate for me to say, and by the way, there's a specific statute for doctors, dentists, and there's a few other medical professions that permit or prohibit non-competition. But in general, non-competition in New Mexico is acceptable. And I'm going to talk a little bit more about what it requires and doesn't require. If you're in California, no. Illinois, no. But non-solicitation is, and it's important to understand that. And when I say non-competition, I'm talking about employees, not contractors or other companies. That's wide open. So even in California, so if I want to form a partnership with another company and I just don't want them to compete in certain areas, that's fine. I don't have the restrictions that I might have an employee. The law is trying to protect employees from, being prevented from earning an honest wage and an honest living and supporting their family and their children. So for employees in New Mexico, it needs to be reasonably tailored in time and scope. This is prohibited in some states, like I had mentioned, but in New Mexico, it's acceptable. And what is reasonable in time and scope? And it's going to vary. There's no bright line test here. So, if you were a HVAC installer, for instance, it could be considered reasonably tailored in time and scope if it was a year and a certain radius, 2 miles, 3 miles. I've seen 10 miles. That's getting a little questionable. I've seen stuff for the entire state. that's generally not going to be reasonably tailored unless it's a specialized area. It seems like the more the specialty, the broader the region has been permissible, versus like a hamburger flipper. Don't try to put a non-compete with the line cooks. That's not going to be viewed as acceptable, and probably not going to be supported. Versus like you had somebody who was a highly trained geologist or something, then that might fly. But it really depends on the type of individual, the specialty, and you probably want to consult with an expert if you really want to dial that in. There's also I didn't put that in the presentation here, but it's called like blue penciling, or the ability, you want specific language that says, look, if our scope or our in time is too big, too broad, and the court is about to knock this down, we're going to allow the court to narrow it to what they think would be legally acceptable. So it would permit your contract from being voided entirely to being modified slightly to accommodate whatever the judge thinks is reasonable under the circumstances. So you want both of those in order to pull this off, at least in the state of New Mexico. For employees, for companies, partners, non-employees, you don't have to worry about that so much. And so you have broader options and opportunities. Now, there's another component to the non-compete, and that is, the scope relating to general or specific. Are we saying you can't compete at all for any reason whatsoever? That would be general, and we got to be really tight with the reasonable tailored language. If it's relating to your trade secret information, your confidential information, your sensitive information, that's a different ballgame. So if you're an employee of mine and I say, oh, you can't practice legal services in the state of New Mexico for 3 years, I don't believe I'm going to be able to enforce that very easily. Versus if I say, you cannot compete with us using my customer list, or the information you glean from our technology somehow. That is better. That's easier. I can enforce that a little bit more, because why? The trade secret sensitive information is ours. We've took a reasonable effort to maintain the secrecy. It's trade secret information. So no, you can't use it, and you can't compete with us using that information. If you're going to go and do general advertisements, well, we can't control that, but we can certainly control you using our sensitive information in competition with us. Non-solicitations are easier to enforce. And you need to understand the difference between non-compete and non-solicitation. Non-compete says, I don't care who you're servicing or who your customer is, you can't do it. Non-solicitation is kind of the reverse, saying you can't solicit our customers directly. You can't solicit our employees directly. You can't provide services to our customers. Don't do it. That is a non-solicitation, and that's much more enforceable. But remember, it's more narrowly tailored. It just ties to my customers, not the entire world. That's a non-compete focuses more on the whole world. Non-solicitation focuses more on my specific relationships, and that we can control with a non-solicitation. Now, I want to warn you, by the way, I've seen contracts where I'll talk to a doctor. They're saying, well, it says, non-compete here, so this whole contract's void, right? I could just throw it in the trash. And I'll say, well, what does the language say underneath the header non-compete? And it turns out the language is non-solicitation. So don't rely on the headers. You've got to look at the actual language underneath the headers to see what it's actually prohibiting or trying to control or restrict. Non-disclosure is what you think it is. It is not disclosing some sensitive information, but you want more than that. You want to not, you don't want them to maintain that information, number one. So they need to return it, or they need to destroy it. Also, you don't want them to use it. right? So just not disclosing is not enough. You could, if you sign a lot of NDAs out there, simply say, we're not going to disclose. And it's like, okay, great, but you're this multi-million-dollar conglomerate. You don't have to disclose it, but if you use that information, I'm screwed anyway. So you don't want them to use either. So don't just sign an NDA because it says the word NDA on it. You want to look and make sure it has these 3 specific pieces to it. And, or if you have your own contract with your contractors, vendors, employees, partners, you want that language in it as well. What is confidentiality? It says you're not going to disclose. It says you're going to destroy or return my confidential information. It says you're not going to use it without my permission. That's what we care about. So I hope you're understanding that contracts are really important. And there's kind of they're the flip side, in my opinion, of protecting your sensitive and confidential information. And I'm just going to run through this really quickly. We're towards the end of the seminar, but I just want to plant a little seed in your mind about other important clauses that you should think about when you are reviewing your existing contract. Somebody throws a contract in front of you, or you're creating a new template contract for your business. And that's going to be, we talked about confidentiality. We talked about non-competition, non-solicitation, and trade secrets, but there's more. There's limitation of liability. Limit your exposures. If they hurt themselves, you want to try and minimize that. If you have an LLC or corporation, good job. That'll help with, catastrophic events. It'll limit the liability personally for you attaching, but you would also like to keep that LLC from incurring too much liability itself, and this will help. Limited warranty. We talked about warranties and what a lot of businesses, products as well as services will have what's called implied warranties that you might want to disclaim. Indemnities. That means you get reimbursed for your losses, your damages, harms that happen to you because of somebody else's stupid behavior. Dispute resolution. And I mentioned attorney's fees earlier. You also want jurisdiction. Why should you have to go, and if you're in Albuquerque, you have to go down to Las Cruces to defend yourself or sue somebody? Ideally, you'd like to do it in your home city or home county. Acceptance of IP. And so I talked about that earlier. What is your intellectual property? What are your secrets? Do they promise to keep that stuff confidential? Do they promise to help you perfect it? If they're a contractor, by the way, they will own the copyright. So the products that they produce for you. So you want a work made for hire clause that will give the IP, the copyrights to the business versus them holding on to it. Right of first refusal. Is there some sort of asset or thing that you want to get a hold of somehow? If you have an older landlord who might want to sell the property someday, see if they're willing to throw a right of first refusal. So if they do sell the property, you get an opportunity to buy it for the same terms and price that they have another buyer for. That might really put you in a great situation someday. Acceptable use. What is permissible? What is not permissible? What will they do? What they won't do? I had a trucking company I was talking to today, and what they said was they have a big problem because their drivers using their trucks, meaning my clients' trucks, the company's trucks, they will go and do a load, but then they'll keep the truck, try to keep the truck an extra day or two and do loads on their own using company equipment. That's a big no-no. That's not acceptable use, and that needs to be defined properly. Notice requirements. If somebody gets sued, somebody gets in an accident, somebody gets hurt, do they need to notify you within a reasonable amount of time? And if so, how do they do that? If they have a claim against you, they think you provided shoddy service or your product is bad, well, we probably don't want them coming back in 6 months or 2 years. Give them 30 days, 60 days. If you got a problem, you need to tell me within 30 or 60 days. Otherwise, done. I'm moving on. Insurance requirements. Do you have those or need any of those? And we're out of time, so I can't go into the real world examples, but I did talk about the theft of the customer list. And it's a really fascinating story that I don't want any of you business folks to have to be in. And it turned out the employee that left, his father was a judge, a bankruptcy judge, not an IP guy. And so he tried to just, pull every kind of ridiculous argument you might think of. And it was expensive for my client was the problem. Because I had this judge thinking that, he's just going to walk all over us. And, and now what are we going to do? We're going to go and file a lawsuit. He's going to have to recuse himself, but he's friends with other judges. So it just created a weird, bizarre situation. So we don't want you to be in that. And then also I had an e-cig customer who ended up having their recipe box literally copied, and then they were dealing with a competitor across the street with those recipes. And the problem was my client wasn't treating that as trade secret information. So it created a big problem down the road. We do have a couple of minutes left. Are there any questions or anything anybody wants to ask before we close it up and have last minute words from SBDC?
I'm not seeing anything on my end. Don't hesitate to ask questions. That's what we're here for. So yeah, don't be shy. And in the meantime, thank you all so much for joining us. Please visit our website at nmsbdc.org to view our upcoming no-cost webinars or to sign up for our no-cost counseling services. The New Mexico Small Business Development Center is here to help you during any stage of your business, so don't hesitate to reach out to us. And most of all, thank you so much, Larry. Are there any more slides or is there anything you wanted to say on your end at this stage?
Nope, that is it. Other than
looks like we got some questions popping in. Thank you.
Of course. Should I just publish my email address so that if anybody has questions, or is it's actually better, Jeff, to contact NMSBDC directly, and then they can give you my contact information, and they can also make other experts available to you to answer the right questions for you. So contact the New Mexico SBDC. And then Marie asked, can you talk about trade secrets again briefly? Yes, but I'm not sure exactly. What I would recommend is contact the New Mexico SBDC, and they can give you a copy of this presentation. And in there, I had a couple of slides with the look like a vault. That is going to be the legal definition of trade secrets. And I'd recommend reviewing that and knowing it. And then if you have more questions, then contact the New Mexico SBDC and they'll give you my contact information. They also have, what do you guys call it? Is it the Business Accelerator? It's the IP group that can answer questions for SBDC
yes,
customers?
It's the International Business Accelerator and Technology Commercialization Accelerator Program. That's a little bit of a mouthful there, but if you contact us, we can let you know more about that. Best email address to reach me at is nmsbdcwebinars@sfcc.edu. I will send that through to you in an email as well, so no need to write that down. And then Larry, just wanted to let you know we've got a great thank you coming at us here as well. And I think that's it as far as questions. Another comment here. Thank you for your time, Larry. It was great. A big round of applause. Yeah, thank you so much, Larry. We always appreciate you sharing your knowledge and just love your webinars. So thank you so much for the presentation and the wonderful information. And thank you all for your attendance.
Thank you, everyone. Take care. Stay safe.